At this time, I'd like to invite everyone to join us in a Pledge of Allegiance. Thank you all. Moving on to the approvals. Do we have a motion to approve the minutes?
Motion to approve.
Moved by Mr. Jones. Oh, actually moved by Mr. Cross, seconded by Mr. Merca. Any corrections or objection to the minutes? Hearing none, the minutes are approved. On to special order of business. Does anyone have any disclosures?
Through the chair.
Mr. Cross.
I have multiple disclosures. Regarding case S12814, petitioner Casey Knight is a 1099 subcontractor through a brokerage. I am president and broker of Real Estate Brokers of Alaska. Casey Knight is a 1099 independent licensee. However, regarding this case, I have no specific knowledge of this case. I have no interest, either personal or financial, in this case. No immediate impact in the matter, and I can remain partial and exercise fair judgment.
Thank you, Mr. Cross. Does anyone have?
I would just make a motion that I would.
Since you have several disclosures, we're just going to go each one.
The next is S1.
Oh, Mr. Cross, yeah. Let's rule on the first disclosure. Does anyone have any objection to Mr. Cross's participation with respect to the disclosure they just laid out?
Through the chair, this is Brenda. I'm having a really hard time hearing. Could you repeat the disclosure for me, please?
Yes, regarding case 12814, petitioner Casey Knight is a 1099 licensed real estate professional at the same brokerage I am, Real Estate Brokers of Alaska, where I'm president and broker in charge. He's 1099 and conducts his own business. And as I stated, I have no specific knowledge of this case, no interest in the case, whether personal or financial, no immediate impact in the matter, and I can remain impartial and exercise fair judgment.
With that, are there any objections? Mr. Cross, if you are able to remain impartial, you can participate.
Thank you.
Now let's hear your next one.
I'm going to put the three of these together because they all apply. In case S12810, case 12811, and case S12812, all three have Tony Hoffman of Boutte Company as petitioner's representative. I have recently hired Boutte Company and Tony Hoffman to do a updated as-built on a piece of property I have. Purely professional relationship. I have no specific knowledge of this case, no interest in the case, whether of these three cases, no interest of them, whether personal or financial, no immediate impact in the matter, and I can remain impartial and exercise fair judgment. So I ask the board to allow me to participate in these cases. Thank you.
Thank you, Mr. Cross. Are there any objections to Mr. Cross's disclosures, or does anyone feel he would be unable to participate? Seeing none, if you can remain impartial, you can participate.
Thank you. Those are all my disclosures this evening. Thank you, Chair.
Thank you. Are there any other disclosures? Not seeing any. With that, I have two myself. Both of them are on case S12781. My first one is we've used Jonathan Lang at Lang & Associates in the past for surveying services. I have no knowledge of this case, no personal or financial gain. So I wanted to list that one out. And then the other disclosure that I have is on this same case, S12781, and that's that I've used McCollum & Rounds in the past for legal services. Again, I do not have any knowledge of this case, financial or personal gain. And with that being said, I would like to open up to the board to see if anybody has any feelings about me being able to participate in this case.
To the chair, I would just make a motion that you would participate in this case.
I'd second.
Just restating, because Skylar's the chair, he had to reassign the chair. So through the chair, I move that Skylar Quinn participate in the cases that he has disclosed. He has no personal knowledge, financial interest, and to remain fair and impartial. Thank you.
I would agree and have nothing additional to add. We could have someone second, thank you. Moved by Mr. Cross, seconded by Mr. Marca. Are there any objections? Seeing none, Mr. Quinn can participate.
Thank you, Mr. Jones. Are there any other disclosures?
I do have one on 3 cases as well. So on case S12812, case S12811, and case S12810, I as well have worked with Tony on multiple projects. None of these projects I'm aware of. I cannot completely impartial with, I'm fine to vote.
Thank you, Ms. Ploy. Do you have any personal or financial gain in any of these cases?
I do not.
Thank you. Does anyone have any issues with Ms. Ploy's participation in these cases? Seeing none, you can participate. And I actually do have one last disclosure. In case S12806 from our last meeting, I was not there, so I will have to abstain from the consent agenda, from voting in the consent agenda. Thanks. For information only, we have an abbreviated plat action summary dated 1/21/25. Do we have a motion to approve the consent agenda? Moved by Mr. Jones, seconded by Mr. Cross. Does anyone wish to poll the resolution for discussion? Are there any objections to approving the consent agenda? Hearing none, the consent agenda is approved. Moving on to new business. The procedure by which the public may speak to the planning board at its meeting is: 1, after the staff presentation is completed on public hearing items, the chair will ask for public testimony on the issue. 2, persons who wish to testify will follow the time limits established in the commission rules of procedure. A, petitioners, including all his/her representatives, have 10 minutes. Part of this time may be reserved for rebuttal. B, representatives of groups, community councils, PTAs, etc. have 5 minutes. And C, individuals have 3 minutes. 3, when your testimony is complete, you may be asked questions by the board. You may only testify once on any issue unless questioned by the board. 4, any party of interest wishing to appeal shall first file with the planning director within 7 days of the board's decision made on the record a written notice of intent to appeal in accordance with AMC 21.03.050A.4A. The following approval of the written findings of fact and decisions, any party of interest may, within 20 days, file an appeal by filing a notice of appeal and paying the appeal fee and deposit in accordance with section 21.03.050. The notice of appeal must be filed with the planning director on a form prescribed by the municipality. If the appellant is not the applicant, the appellant's notice of appeal shall include proof of service on the applicant. Now, may we have staff's presentation in case S12781.
Thank you, Mr. Chair. This is a request to subdivide one lot into 2 lots with a variance from AMC 21.08030K1. Depth of the lot shall be at least 80 feet. Just a note, if this lot were 80 feet or deeper, this case would have been handled administratively and not come before the board tonight. No reviewing agencies had objections to either the requested subdivision or variance from minimum lot depth. Relevant comments from each agency are found on pages 3, 4, and 5 of your staff packet. Variance requests must meet all 4 standards. Again, the petitioner is seeking a variance from AMC 21.08030K1 lot dimensions to allow proposed lot 1A to have a depth of less than 80 feet. Standard 1, there are special circumstances or conditions affecting the property that the strict application of the provisions of the subdivision regulations would clearly be impractical, unreasonable, or undesirable to the general public. This standard is met. The withdrawal of the remainder of this lot creates 2 separate lots requiring the need for this variance to minimum lot depth. Without this variance and lot combination, the withdrawal portion would likely remain unused. This subdivision is served by public water and wastewater. Standard 2, the granting of the specific variance will not be detrimental to the public welfare or injurious to other property in the area in which said property is situated. This standard is met. The granting of the variance will not be detrimental to the public welfare or injurious to other property owners in the area. The granting of the variance would allow proposed lot 1A to have less than the required 80 feet in depth, but still remain usable. Standard 3, such variance will not have the effect of nullifying the intent and purpose of the subdivision regulations of or the comprehensive plan of the municipality. This standard is met. This variance will not affect effect of nullifying the intent of the subdivision regulation. The granting of this variance will simply allow an R2M lot with 10,793 square feet and approximately 74 feet in depth, about 6 feet less than the required 80 feet. Just for record, minimum lot size in the R2M is 6,000 square feet. Standard 4. Undue hardship would result from strict compliance with specific provisions or requirements of the subdivision regulations. The standard is met. Undue hardship would result from strict compliance with the subdivision regulation. If the variance is not granted, then the owner would not be permitted to subdivide this remainder parcel. This subdivision of the property will allow the owner to use the property in a way that is not detrimental to the public nor an unreasonable use of land. Therefore, the department recommends approval of the request for a variance from AMC 21.08030K1, subject to the recording of a final plat within 24 months and the approval of the plat for 24 months, subject to conditions 1 through 4 found on page 6 of your staff packet. I can answer any questions you may have, and the petitioner's representative is here to present.
Thank you, Mr. Hatcher. Do we have any questions of staff?
Through the chair.
Mr. Cross.
Do you have a queue? I don't see a request to speak, so we can get in the queue if there's more than one. Nobody else? I have a question for staff. It goes back to the variance request. Section number 2, granting of the specific variance will not be detrimental to the public welfare or injurious to other property in the area in which said property is situated. We received a last-minute public testimony, basically a lay-on-the-table item. It sounds to me as if there may be a contentiousness between the Street Line Construction, who is on title as far as the property owner, but also the members of the HOA, which also have fractional ownership. Are those things typically rolled out when we take these things, number 2, into consideration? I can't remember hearing a previous plat case where we had potential disputes between a developer and the HOA. And I'm kind of curious on how those are typically resolved before they land in our lap.
Through the chair, Mr. Cross. So the planning board is here to decide whether or not they meet the subdivision requirements and the variance requirements, and not a civil matter that is between two property owners. There is one other case that was similar to this, done in 2012, Aspen Heights subdivision. It's off Northern Lights and Wesleyan, just north of Northern Lights. They had the property, the underlying owner had ownership similar to this. They had a southern piece of the property that they had to subdivide away from the existing built structures to the north so that they could, I'm assuming, to get financing. I can't remember exactly why that happened, but this is common. This, not super common, but this is common enough. It does happen. Does that answer your question?
Yeah, so what you're saying is we're just strictly looking at the land use, whether or not there's other legal contentious items, that's beyond our purview.
Correct. That's a civil matter, not to be decided, or needing to be decided by you as the planning board.
I appreciate those, yes. And I remember the Aspen Heights. I think I was on the
I believe you were.
The two brothers that were the builder. Thank you.
Mr. Jones, do you still have a question?
No, that one was similar to mine. Thank you.
Thank you. Are there any other questions of staff?
Yes, through the chair, this is Brenda Butler. I do have a question for staff.
Brenda, can you speak up?
Yeah. I have a question. Let me know if you can hear me.
Just barely, so do your best.
Okay, I'll try to speak up. Okay, so my question is, under 2108030I, the name of the subdivision, so the title under which the subdivision will be recorded shall not duplicate the same name of any existing subdivision in the municipality. So when you look at the attorney letter in the platting packet, it states that this is a withdrawn property and it's no longer part of the 16 South Condos HOA, and that the withdrawn property is essentially a separate parcel. My question is, wouldn't this platting action call for a rename of the lot or the subdivision?
Through the chair, Ms. Butler, yes, so the lot numbers will change. It can remain as the same subdivision name. The lot number, though, cannot remain the same, and so the lot numbers will change to indicate that.
Okay, it just said that in 2108030, it said that the name shall not be recorded as a duplicate name if it was a different lot. So I just needed clarification on that.
You're welcome.
Thank you, Ms. Butler. Are there any other questions of staff?
I have one question. Through the chair, I'm just a little curious about how the ownership structure of this lot really works. I don't think I've wrapped my head around that. The withdrawn section, is it owned separately from Lot 1 as it exists today?
Through the chair, Mr. Murphy, yes, it actually has its own tax ID number. The municipality's actually granted it its own tax ID number separate from the other one. I can't speak legalese to you when it comes to condo associations and horizontal regimes and how those all work. But like I kind of explained to Mr. Cross earlier, the board is just to look at, is this a valued, or can this be subdivided? Can the variance be granted? Have they met the requirements for that? Does that help? Okay.
Thank you, Mr. Merca. Mr. Jones.
Thank you. So in this late document that we received, on the third page, second paragraph, there's a section that states the property line for lot 1A cannot be placed as proposed, however, without creating a non-conforming setback violation on the remainder parcel of Lot 1B. Is that in the plot that we received? There really isn't any information given on the other condos essentially aren't shown on it. So was that something that was reviewed? Can we verify if there is indeed some sort of issue or setback that's going to be caused by this? Or and then second to that, there's a second part of this where encroachment further erodes the privacy and distance between structures, which is contemplated and protected by R2M zoning. Is there anything that you're aware of in R2M zoning that would state that?
Through the chair, Mr. Jones, I would defer on the dimension to Mr. Lang, because he's the one who did the as-built. From the exhibits that were provided, as you can see on page 27, it appears that units 14 through 18 would maintain the 10 feet of rear setback, and in this case, it's probably even side setback. I'd even say it's maybe side setback. But R2M is 10 feet for rear setback, but that is correct. We were not provided with an as-built that dimensioned it to the exact line of where this withdrawal was taken from. So that would be a question for the applicant's representative. You had one other question. I can't remember what it was.
Yeah, sorry to bulk it all together. It was the last part of that same paragraph where it discusses the screening requirements in R2M. I wasn't aware of anything there, but maybe you could speak to that.
That is correct. So if you have R2M abutting R2M as residential uses, there is no landscape screening requirement in abutting zoning.
Perfect. Thank you for clarifying.
You're welcome.
Thank you, Mr. Jones. Are there any other questions of staff? Seeing none, can we move on to the petitioner's presentation? Go ahead.
Mr. Chair, members of the board, staff, and members of the public, I'm Jonathan Lang of Lang & Associates Incorporated, professional land surveyors, and I'm here presenting on behalf of the property owner, Evelyn Irvin and Shearline Construction. I ask you to please open your staff reports to the graphic on page 27. The 16 South condominium project was started by Shearline Construction, run by Pat Irvin, Ev's husband. Pat passed away in October 2019 before the condominium project was completed. Ev not only had to deal with her husband's grief, she had to take over completing the condominium project. Condominiums have development rights which expire after a period of years unless the rights are extended by agreement with the condominium association. Ev was unable to reach an agreement with the 16 South Condominium Homeowners Association and withdrew the undeveloped portion of the project from the condominium as allowed by state law. The graphic on page 27 shows 18 fully developed units and the vacant withdrawal parcel. Had the original condominium project been completed, there would be 2 more townhouse-style units on the withdrawal parcel with access directly to Lake Otis Parkway as originally planned in the project. Had the condominium been completed, there would be no need for this plat. The plat you have before you places the legally withdrawn parcel on a lot separate from the condominium. In the pre-application conference held last fall, it was disclosed that the proposed lot did not meet the minimum required lot depth. This is the variance we are seeking tonight. Staff in their presentation stated that all of the requirements for the variance are met, as noted on pages 5 and 6 of the staff report. Staff also has a list of 4 recommendations on page 5 of the staff report, which are reasonable and agreeable. We respectfully ask that you approve the plat with the 4 staff recommendations and the requested variance. Thank you. I ask to reserve the remainder of my time for rebuttal, and I am available to answer your questions.
Thank you. Do we have any questions of the petitioner's representative? Mr. Jones.
Thank you. To follow up on the question that I asked of staff, can you verify that the dimensional requirements here on the condos that face this or back rather to the new lot that would be created here meet all dimensional standards as needed for setbacks?
They do. What's not shown on here is the decks on the rear of these units, and based on the condominium plat which has been recorded, those are shown at a little over 5 feet from that, what was the unit line between units. The minimum setback requirement, it was adjudicated at the pre-application conference that this would be considered a side yard, so 5 feet would be the minimum. And those decks currently meet that.
Thank you.
Do we have any other questions? I'll let this sit just a little longer. With that, we're going to open up the hearing to public testimony. We're going to start with testimony here, and then we're going to move on to the phone line. So anyone at this time is welcome to come on up and testify. You have 3 minutes.
Is that better? Okay. My name is Shane Osuski. I'm the attorney for 16 South Association, which is the condo association that owns 18 members that own part of the lot being subdivided. We own it in undivided common interest. We disagree with the comment that this withdrawal was allowed by state law. It was prohibited by state law. We did not fight it at that time. It wasn't worth the legal battle. But now that we have a variance coming up here too, they're penciling in a property line that we never agreed to. And the property line does encroach into our property. If you look on page 9 of the handout, there's an aerial view showing, and it's a first story deck and a second story balcony, and it shows them right in the back. If you look on page 9, they're clearly depicted. And so if this property line is drawn in where proposed, these units will no longer have a backyard. And that, we contend that that's a big problem, that they can't just draw a property line in wherever they want without our consent, because it's our property as well. We provided a letter that outlines more the rest of our concerns, but essentially 18 of the property owners are being ignored in this variance request because we also own the property. The withdrawal portion was illegal to start with, but now it's being platted in a way that they could put the property line across the sidewalk. They could put a property line anywhere they want, and it's our property as well. We don't agree to the property line being there, and it's creating a problem on the newly proposed Lot 1B, which will now have no backyards in our condo project. The landscape screening, I didn't mention landscape, and I apologize if that was confusing. We weren't referring to landscape screen. Our reference was some other project is going to be built on this property, which is inset into the condo, and it'll be right outside the sliding glass door, right off the deck on the first and second story of these 5 buildings. So they'll be staring right into somebody else. The whole point of R2M zoning is to require a 10-foot buffer in your backyard, so that doesn't happen. So this is going to be, we're going to have a smaller than normal lot next to us, so it's going to be crowded, and then we're also creating an encroachment problem into the setback on our property by putting a property line there. So that property line could have been just as easily drawn right across the back of our building, and we wouldn't have any backyard. And that's the source of our objection. So it creates 2 problems. You have an undersized lot, and you're creating a problem as well by wiping out our backyard on proposed Lot 1B. So that's, this developer they've created, the petitioner created these 18 condos. Once you sell a unit, build and sell a unit on a platted piece of property, you're no longer able to withdraw and replat that property. This shouldn't have happened in the first place. They just drew this in, and they've been marketing it for a year. I assume they have a proposed buyer while we're at the stage. I don't know that for a fact, but it has been marketed on MLS. And it's not a proper property. Now their letter says as much as well. The attorney letter they submitted from Attorney Rounds mentions that they have to comply with zoning requirements, that a withdrawal that would violate setbacks would be a problem. That's exactly what we have here. And if you, a simple reading of 3408-180 says you can't do this. Once you've built a condo, you can't change the property line. And that's exactly what's happening, and they're not meeting their subdivision requirements. So we have both objections that are, and the comment about does this meet the requirements for a variance affecting adjacent neighbors negatively? It does. And the first comment about this property otherwise could not be used, it would be used as originally intended as common area for the condo association. So that was what was originally provided when they built the 18 condos, and now they want to pull it out and put something else there. Well, I guess we dispute whether that was allowable, but we dispute whether it meets the requirements because it does adversely affect the direct neighbor. We're drawing a property line that wipes out our backyards. We're putting an inconsistent development right in the middle of us. It's not even a carved off unit, it's actually inset. And normally a condominium is, we have a higher density development, but that's alleviated by the fact that there's a condo association with a board and consistent, construction and some governance board internally to handle close neighbors. Here we're going to have a close neighbor literally right next to our sliding glass door that's not part of our association, can be built any way they want with no repercussions at all for the condos. So we do ask you to look at that. It's not an adjacent property, inset to our property. If there's any other questions, I've outlined our concerns in my letter as well. Thank you for the opportunity.
Thank you for your testimony. Do we have any questions of the testifier? Oh, Mr. Cross.
Thank you. Appreciate you coming in this evening. I have a question. You had mentioned that the units face towards the backyard facing this lot. You said they're losing their backyard. It does look like in these pictures, though, that there's a fence in there. So are these yards don't extend into this? It looks like those are actually separated with fence. Is that correct?
We're uncertain exactly where the fence exists. We assume it would have been built with buildings facing each other, so there'd be like a combined backyard originally. And we do know where the decks are placed. We've measured, and it's not a couple of feet. The lower buildings are shown on Phase 5 plat as 8 feet out from the building. The upper 3 decks are shown as 6.2 feet out from the building. So it's not a 5-foot situation, but I'm not sure about exactly what the fence is. That's not shown. I don't have a measurement.
Yeah, I guess it just brings in question whether or not the existing property are influenced, because if they're 10 foot from the edge of the property to the property line, the deck that sounds to me like those properties have so now exacerbates side. All right, thank you.
Thank you. Do we have any other questions of the testifier? Seeing none. Mr. Jones?
Yeah, sorry. And through the additional information that was provided, I thought I remember seeing it somewhere in here, but it seemed like there was some discrepancy between what you stated that this was meant to be common space, because somewhere I read in here that it seemed like this was meant to have some additional development on it. So I guess can you clarify that it was intended to be common space, because somewhere in here it seemed like maybe it was just this public comment on the back. I'm skimming it now, but it seemed like there was some plans, or at least that was stated or presented to the condo association, that showed some additional units being constructed there.
You are correct that original plans were to put 3 additional units on that area, but the earlier plats show need not be constructed. They didn't have to construct it. And the same thing goes along the mailboxes. There was some guest parking that said need not be constructed. But everything outside the units is considered common area. When they made Lot 1, they merged the whole thing together. And so just as the guest parking areas, the areas around the mailboxes, the areas around the entryway, everything that's not shown in the units on page 27 would be common area. And they're trying to withdraw the top left corner. They could just as easily have withdrawn the guest parking area next to Lot 5 or the mailbox locations. Everything outside the units is considered common area. But you're correct that there was originally plans to build 3 additional units as part of the same condo.
Thank you.
Thank you. Any other questions of the testifier? Seeing none, would anyone else like to testify? Please state your name for the record.
Michelle Maisley. I'm a homeowner at 16 South. Thank you for allowing me to give public testimony. I am also a member of the HOA board. We're a volunteer board. There's 3 of of the 18 units. And when we bought our units over 5 years ago, we never anticipated having to be here tonight. We assumed the understanding was that all 21 units would be built and completed for the 16,000. So here we are. And I just wanted to point out that in Shearline Construction lawyer's letter in the package, there's a few points that I don't agree with. He said that that we don't have any ownership interest or any beneficial interest to the empty lot, but in fact we do. I mean, we wanted the 3 units finished, and we wanted the revenue from the 3 units towards our HOA common expenses. We wanted to maintain the character and the viewscape of our condo association, and that's been lost. So having said that, if the plat does go through, and hopefully it'll be with some modifications that have been recommended in the package, I ask that you consider I think it's the Anchorage waste and water recommendations. Apparently there's an existing sewage line, water and sewage line that runs to one of our existing buildings. And I ask that you look closely at how we can maintain access to that without any onus on the 16 South HOA. That if so, I ask you to look at that easement. Also, apparently the decks. I think the decks are a problem. There's a fence that was put in by Shearline, actually an L-shaped fence. I don't think it has anything to do with property line or this withdrawal. So I ask you to consider where the decks are, the end of the decks are, and if the fence needs to be moved for easement purposes, then we ask that the cost of that be associated back to Shearline, and that the HOA does not, that we don't take on any costs for moving the fence or anything to that effect. And also, apparently, there's Chugach requires another easement, a telephone and electric easement on the south side of the property, withdrawn property, that I ask you to consider as well, I guess. And that is it. Thank you.
Thank you. Do we have any questions? Seeing none, would anyone else like to testify? Please state and spell your name for the record.
Now is it on? Yes. My name's Tina Maynor. I live at 7731 Centergy Lane. I'm on the board as well. We have lived there since 6 years. We take great pride in our little neighborhood. You know, we maintain it beautifully. We're proud of it. I feel so sorry for the condominiums that butt up to this lot, because they're getting screwed. They're not going to have any, you know, depending on what gets built there, their landscape view will be gone. I think there's a fairly big safety issue with, we have Synergy Lane comes off of Lake Otis and then makes an L to connect with the rest of the condos. But whatever gets built in this area, the driveway is going to exit and enter right off of very busy Lake Otis. So I think that's a consideration that I wouldn't want to have to deal with. I also am concerned about the utility issues and whether all of those, whether there's room in that area to handle the water and the sewer and the telephone and the the electric. We know that the original contractor, he was a great guy. We liked him a lot. He had some nice plans that unfortunately he didn't have time to finish. But his plans did account for an underground garage, which would have been a lot easier on that parcel of property for people's views being obstructed and not looking straight into your neighbor's house. But that's all an unknown at this point. So I really encourage you to vote this down, and we'd like to preserve the neighborhood because it's a very nice one. It's very close to everything. We love it. Thank you.
Thank you. Miss, can you please spell your last name for the record?
Yes, sure. It's Maynor.
Thank you. Anyone else wishing to testify? Oh, I believe Mr. Jones has a question.
Thank you. Yeah. So, with you living in the development there, can you confirm? I just want to make sure the aerial appears that there is fencing on the backs of the properties, condos 14 through 18. So I do want to just clarify that that fencing does exist. It's in place now.
Mm-hmm.
Okay. Perfect. Thank you.
Thank you. Any other questions? Seeing none, would anyone else like to testify? Please state and spell your name for the record.
Yes, my name is Alex Traxler. I'm a homeowner at 16 South. I live on 7725 Synergy Lane. I'm here to show you that, this is a problem, for our community. There's, people like myself, that are being impacted by this. When we bought our unit, the understanding was that if something was going to be built, it will conform to the rest of the subdivision. And by doing this withdrawn, seems like, we are kind of losing control over, what is being built. We have a very nice community. We take a lot of pride in how it looks. And it would be a shame to see something, who knows what, being built there that will affect, not only our property values, but how our community looks. I'm one of the lucky ones. I don't have a backyard, facing this lot, but I do have neighbors that might lose their view, based on what is being built there. So I respectfully like to request that this request to withdraw this, subdivide this lot, be denied. Thank you.
Thank you. Can you please spell your last name?
Yes, Traxler, Traxler.
Thank you. Anyone else wishing to testify? Seeing none, I think we're ready for the rebuttal.
Thank you, Mr. Chair.
And you have 8 minutes left.
Thank you. I'm a land surveyor. I'm not an attorney. To the best of my understanding of the law, the concerns raised by the condominium's legal counsel are addressed in the letter to the Planning Department from Attorney J. Taylor Rounds on pages 18 through 22 of the staff packet. Had the Homeowners Association allowed the development rights to be extended, which they could have done, there would be three townhouses units that match the existing development. Because we are replatting this into a smaller lot, it will be restricted to 2 units. and it's at the whim of whoever develops that to make them look how they would. So the homeowners association fully had the power to extend those development rights and allow this development to be completed as intended to match their own. I think that their council has misrepresented and misunderstood what the common area and how that works is.
Welcome back, everyone. Just for the record, we had a fire alarm go off. We are now resuming the meeting at 7:42. Mr. Lang, you were giving your rebuttal testimony. I think most everyone forgot what you said, so we are restarting your time, your 8 minutes that you had remaining, so go for it.
Thank you. I kind of lost my train of thought myself. Start over. I'm not an attorney, and to the best of my understanding of the law, the concerns raised by the condominium's legal counsel are addressed in the letter to the planning department from attorney J. Taylor Rounds on pages 18 through 22 of the staff packet. Had the HOA allowed the development rights to be extended, there would be 3 townhouse units that match the existing development. My understanding is with the zoning code the way it is, because this is a smaller lot, it'll be restricted to 2 units. So it was definitely to the developer's advantage to extend those development rights so they could build out the entire development as it had been planned. I believe that the council for the HOA is misunderstanding the common areas. This area that was withdrawn was specifically designated on the latest condominium plat as development rights reserved. And that is what was withdrawn from the condominium. It was never placed as part of the common areas. The parking that they were talking about and the other open space areas were specifically designated in the declaration for those purposes. And in those declarations and on those plats, it states clearly that they are not subject to development rights. This withdraw area was specifically noted as development rights reserved, and that's why it was and is legally allowed to be withdrawn. Where the fences currently exist is where the condominium plat says the unit line is. A unit line is different from a lot line in a legal semantics way. It's a unit because it's a condominium versus being a property line, which is fee simple ownership rather than common ownership. So the backyards that they currently have would not have been any different had the development been fully built out. So we're not changing their rights and interests. We're not arbitrarily creating a property line. That is a misleading and a misconception. What happens if the subdivision is not approved? The parcel remains vacant, unsellable and undevelopable. That's 2 fewer homes towards the goal of 10,000 homes in 10 years and potentially an overgrown eyesore. Bear in mind, condominiums are governed by state law, specifically AS 3808, the Uniform Common Ownership Interest Act. The municipality has no interest in the creation or regulation of condominiums. It's not addressed in Title 21 at all. It's not addressed anywhere in municipal code, with the exception of a portion of Title 21 that talks about the development standards for condominiums. The city has nothing to do with the platting of condominiums. The questions and objections raised by counsel for the 16 South Homeowners Association have no bearing on whether or not the platting board approves the plat or the requested variance, and your obligation to fairly adjudicate the question before you in this case. We respectfully ask that you approve the plat, subject to the 4 staff recommendations and the requested variance. Thank you.
Thank you for that. We do have some questions for you. First is Mr. Murka.
Mr. Lang, I'm hoping you can shed a little bit of light on me light for me on side yard versus rear yard when we look at lots 1A and 1B. 1B, it's already been outlined that I think it's that west side is a side lot, and so the deck's encroaching that 5 feet, and then we have 5 feet to the lot line. Is that correct? There's 10 feet total, 5 of it's covered by deck. Is that right on that side lot?
Yes.
On the new proposed lot 1A, where would the rear lot line be? Where would the back lot line be?
Can I defer that to staff?
Sure.
Through the chair, Mr. Merca, it would be the east property line, so the abutting property line to the condo association. So the front property line would be Lake Otis. It'd have two side property lines, the north and the south, and the rear property line would be the east property line.
And on that east property line, the setback requirement in this zoning is 10 feet, is that correct? Or is it greater?
Through the chair, Mr. Merca, depending on the development, if it's a single family or a two-family dwelling, it could be 5 feet up until, if the structure were to be more than 5,000 square feet in size. Sorry, no, it is 10 feet. I'm looking at the side yard yards. Yes, it's 10 feet no matter what kind of development.
Okay.
Sorry about that.
Thank you.
Mr. Jones.
Thank you. In relation to the unit defined that you had and the fencing that's already there now, because it wasn't shown on the plat, where is that fence line in relation to the house now and you know, that common space that's developed for that? How was that impacted by this plat and the sizing of that? Is it same place that you're proposing? Is it less, more?
I believe it's in the same place where the fence line is, and we did look at the code and make sure that everything made sense with the code. We would have had to dedicate additional property if it was less than the 5 feet for those decks.
Okay, thank you.
But it currently meets the code, and the fence line is on the unit line as defined on the condominium plat.
Okay.
Any other questions? At this time, we're going to close the public testimony.
Thank you.
Mr. Chair, I have one additional question, if I could direct to staff if possible.
Fire away.
So, directed to staff, for the variance request shown on page 5, item number 2, the granting of a specific variance will not be detrimental to the public welfare or injurious to other property in the area in which said property is situated. Can you, I guess, define a little bit of how the injurious is kind of defined and how that is looked and what kind of you look at when defining that?
Through the chair, Mr. Jones, so this granting of this variance doesn't create a issue where access is inundated. View shed is not something we would look at. I realize that this is going to block, possibly block somebody's view to the west, but that's not an injurious thing. It's, you know, cutting off access. It's creating something noxious. It'd be like saying, hey, we can put a commercial gravel pit here or something, you know, that type of a, does that help?
It does, thank you.
Yep.
Any other questions? Okay, we need 2 motions. The first motion will be regarding the variance. Do we have a positive motion? Moved by Mr. Cross, seconded by Mr. Jones. Mr. Cross, can you state your motion?
Yeah, I move in case S12718 to approve the variance from AMC 21.08.030K. 1, lot dimension less than 80 foot in depth, subject to recording a final plat within 24 months, plus any time extensions.
Thank you, Mr. Cross. Would you like to speak to your motion?
Yes, I will. So as this specifically goes, this goes towards what we have as far as lot size minimums. I want to make sure that most people understand that, you know, you may or may not know this, but acreage is it was in the process of radically changing the lot size minimums. In fact, if you'd probably waited 12 months, this might not even be necessary, right? So you have your buildable envelope, and then you have your setbacks and restrictions. 55, and then you're 10 feet in the back, 5 on each side, 25 feet in the front. And pretty soon it's going to be that's your buildable area regardless of lot size, because the lot size minimums we've established in code is well established that it's road blocking infill for road. We have hundreds of lots that don't meet these minimum standards once you include setbacks and restrictions, and they're not getting built on. This is a perfect example. Now, I'm not an attorney and I can't get into it. I think maybe some of the homeowners associations, they have a legitimate claim regarding on how those communications took place. But we on the planning board don't get in those civil matters. We just look at, is what they're doing reasonable, even if what they do might block your view or fill in the blank. Unfortunately, that's not something we get into. They can't do things that affect your drainage or run off into your property and flood your crawl space or affect your utilities. In fact, that's the next one goes into, they can't do that. But as far as reasonable construction on smaller lots, this variance of under 80 feet is completely reasonable to allow for infill on smaller R2M lots. And so I support it because this is exactly what the municipality of Anchorage has been trying to do. Thank you.
Thank you, Mr. Cross. Mr. Jones, can you speak to your second?
I can, thank you. I think Mr. Cross summarized a lot of the points that I would be making as well. I do just want to add that I feel that the criteria for the variance as defined by staff does match up with what we're looking at. And again, looking specifically at the merits of the lot size and the dimension there, I do intend to support this. Thank you.
Thank you, Mr. Jones. Does anyone else have any findings that they'd like to add to the record? Mr. Merca.
Through the chair.
Ms. Butler, just wait for a second. I'll get to you after Mr. Merca.
I would kind of like to just echo Mr. Cross's statements. I'm sympathetic to the homeowners here that are adjoining this lot. I hope that in the future maybe there's some harmony between whatever happens on this lot and the homeowners association. But again, as Mr. Cross has stated, our scope is narrow, and I find that these conditions are met. So I will be supporting this motion.
Thank you, Mr. Merca. Ms. Butler, were you going to say something or add findings?
Yes, I would like to mirror Member Cross's voice of the Anchorage ordinance that actually I just read today, Anchorage Ordinance 2024-104F, which is actually going to impact the residential development by suspending design standards. And that, there was time for public comment and there was none received. The community council, the Abbott Loop Community Council did no protest, no comments. It is the access from Lake Otis. It is designed as a Class 3 major arterial, so it can handle access to the lot. And that traffic's recommendation of access will eliminate any need for going through the existing subdivision. So I'm hesitant to, support this variance because I understand the homeowner's situation, and it probably is very disappointing, but it does comply with Anchorage code, so I will have to support this.
Thank you, Ms. Butler. Would anyone else like to add findings? Seeing none, let's call the vote.
Ms. Butler, how do you vote?
Yes.
Thank you.
With 6 yeses, the motion passes. Now we're going to load the second motion, and it will be a motion for the 24-month plat. Do we have a motion? Moved by Mr. Cross, second by Mr. Jones. Mr. Cross, can you state your motion?
I move in case S12781 to approve the plat for 24 months, subject to the conditions shown on page 6 of the staff report.
Would you like to speak to your motion?
Yes. Staff analysis that's found on pages 4, 5, and 6 outline, as far as staff analysis, why I'm approving this plat. The public testimony, what we heard is there was concerns about utility easements through the property. And so one thing that's important on provisions on this second motion, section 3B, property owners and utilities shall not be obstructed, impeded, or altered or alter drainage facilities such as swells or ditches in any way that will adversely impact adjacent properties or right-of-ways. So as far as some of the legitimate concerns from the neighbors about development on this and the negative consequences perhaps on those aspects of their properties, that will have to be resolved. So I want to make note of that. Thank you.
Thank you, Mr. Cross. Mr. Jones, would you like to speak to your second?
I would, thank you. Mr. Cross again summarized a lot of the things that I would also state, but I did, Mr. Cross, you mentioned the section 3 there in the department recommendation, but I did want to mention too B1 where one of the comments that were made was about the utility easement in the back for the sewer line, and that is one of the first things here is resolve utility easements. So that would be subject to this is reviewing that and making sure that that's taken care of properly. So I do intend to support this as well. Thank you.
Thank you, Mr. Jones. Would anyone else like to add findings for the record? Seeing none, let's call the vote.
Ms. Butler, how do you vote?
Yes?
Thank you.
With 6 yes votes and 0 no votes, the motion passes. With that, we're going to move on to staff's presentation in case S12807.
Thank you, Mr. Chair. This is a request to vacate the 30-foot BLM reservation for a roadway along the west property boundary of this lot. On January 10th, 2025, a total of 123 public hearing notices were mailed to the surrounding property owners and residents within at least 500 feet of the subject property. As of the date of this report was written, no public comments were received, and the Huffman O'Malley and Hillside Community Council did not comment. You do, however, have a supplementary F1B that was received after this staff report was written. No reviewing agencies had objection to either the requested vacation of the 30-foot BLM reservation for a roadway on the west side of the lot. Relevant comments from each agency are included on pages 2 and 3. The vacation request must meet all 6 standards. The petitioner has requested vacation and elimination of a 33-foot BLM reservation for a roadway recorded by Book 93, page 95, along the west property line. Standard 1, actually. The vacation requests have been reviewed and found to conform to the municipal vacation policy, which states, in considering any vacation of public right-of-ways, dedication, section line easement, BLM easement, or public use easement, the municipality uses the following to guide the planning department recommendation to the platting board. Standard 1, the statement by the applicant alleging the right-of-way is surplus to the current and future needs of the public and the reasons for determining the right-of-way is surplus. The applicant has attached their statement pursuant to the above application and states that the BLM reservation is surplus to the current and future public needs. The traffic department, engineering department states in their comments that they have no objection to the vacation. This 33-foot BLM road right-of-way easement leads to nowhere and is not connected to anything and has not ever been developed. 2, the municipality will not entertain any vacation of right-of-way on a street on the official streets and highways plan, OSH&P, unless it can be shown without a doubt that the right-of-way is clearly in excess of all future needs for right-of-way. This BLM reservation is not listed in this classification of listing of streets in the OSH&P. The right-of-way is clearly in excess of future needs. Any right-of-way lying on the half-mile grid will not be considered for vacation unless it can, without a doubt, be shown that the right-of-way is clearly in excess of all future needs for right-of-way. This BLM reservation is not lying on the half-mile grid. Any right-of-way lying on the quarter-mile grid will not be considered for vacation unless it can be, without a doubt, be shown that the right-of-way is clearly in excess of all future needs for right-of-way. This BLM reservation is not lying on the half-mile grid either. In all cases, it must be proven that the remaining property in the area can be adequately served and the traffic circulation is enhanced by the vacation of right-of-way. The remaining property will be served by existing dedicated right-of-way. The vacation of the 33-foot BLM reservation will not deny access to any property. The vacation will not have any impact on traffic circulation. 6, the municipality would consider realignment of right-of-way by vacation and rededication where it can be clearly shown the right-of-way realignment will enhance traffic circulation and will provide for the movement of traffic with generally the same beginning and ending points as the original right-of-way. The 33-foot BLM reservation to be vacated along the western property boundary is a remnant from the BLM subdivision of property. There is no realignment of roadway proposed, and the vacation will not impact existing traffic circulation. Utility easements have already been placed on the plat from a prior platting action, 2013-67. Private development, right-of-way, municipal traffic department, and the ADOT-PF have no objection to the vacation because there will be adequate right-of-ways for traffic circulation. Generally, reviewing agencies had either no comment or no objection to the vacation request. Therefore, staff believes that the 30-foot BLM reservation is in excess of municipal need and recommends approval of this vacation subject to conditions A and B found on page 5 of your staff packet. I can answer any questions you might have, and the petitioner is in the audience to present.
Thank you for that presentation. Do we have any questions of staff? Mr. Jones.
Thank you. On the document that was provided to us here, the supplemental information that came in late, obviously with it coming in late, I haven't been able to look at the property that they mention here. I'm not sure. Are you familiar with this property here that says that it's west of the subject property and in violation of code? And if this indeed would have any sort of impact on that between the two streets that this BLM kind of joins?
Through the chair, Mr. Jones, I wish I could pull up the map on my screen. This property is north. The comment from the comment that was received late, they live just north of Mr. Hepler's property on, I believe, East 112th. And for some reason, East 112th doesn't particularly it doesn't go east. It's there, but it's not constructed to any kind of MOA right-of-way standards. So I wish I could show you on a map. It'd be a lot easier. Actually, if you turn to page 8, you can see the petition site. The person who provided comment is the property just to the west along East 12th. They're kind of abutting does that make sense? Am I making sense? So they're just north and west right off the corner of the petition site.
Okay.
And they're on East 112th. And you can kind of see through the aerial that East 112th looks like it goes through to Birch, and it kind of does, but it's not built to any kind of municipal standards. So access actually to this portion of East 112th actually is taken to the west, and I can't remember what street that is off the top of my head, but it's developed right away.
Okay.
And Mr. Hepler probably knows better than I do.
Sure. Okay, but
Dr. Hepler, sorry.
But looking at it though, this particular property, due to the properties that were between this one and East 112th, that this BLM action would have no impact on what East 112th has for access?
That is correct, yep.
Okay.
They currently, like this lot and the other 3 lots, all just take access off Fenwick, off of Birch, and there's no connection, no proposed connection between Fenwick Circle and East 112th.
Okay, thank you for clarifying.
Yep.
Any other questions of staff? Seeing none, I think we are ready for the petitioner's presentation. Please state and spell your name for the record. Mike, turn your mic on. There's a little button.
Green button. My name's Tom Hepler, and I'm the owner with my wife, who's behind me, of 5639 Fenwick Circle.
Hey, could you stand a little closer? It's just not all coming through.
I'm Tom Hepler and the owner of the 5639 Fenwick property. And we are just looking at vacating the 33-foot easement just to actually extend our garage, which was already built, which is already there. So we built it within 33 feet of the BLM easement and just want to continue building it further, which would actually go, I guess it'd be kind of a south direction. And since we built it, then the Muni put in a 25-foot easement. So now to build onto our garage, we would be in violation. So in order to extend our garage, we need to vacate the BLM, which is the easiest way to do it. And so that's all we're simply requesting. And as you can see, the property is not accessible, and the property west of us has already been, the BLM's already been vacated. So I do not understand the other neighbors' concern about 30 properties. I don't know where those properties even exist. And you look at the map, I'm not sure where they are.
Thank you for your presentation. You have 8 minutes and 31 seconds for rebuttal time. Does anyone have any questions of the applicant?
I do have
Sorry,
one
Mr.
question.
Jones.
Yeah. Thank you, Mr. Hepler. The garage that you have here on the west side of your property, on the as-built here that we were provided, there's an arrow indicating carport, and it just kind of has an arrow towards the west side. The way your garage is set up, it's not configured like an L, right? It's just straight, and it's
just
all
straight.
okay, and it's all outside of that 33 foot, right?
Yes.
Okay, because the way that it looks now, there's a line there, which I think is just the gravel driveway, but it kind of makes it look like the carport is part of the 33-foot easement. I just want to clarify that everything is currently outside of that easement.
To clarify that, I've been talking already with the Muni about that. I'm going to take down the carport, so I'm conforming with that. But they've agreed to let me do the building first, and then I can take it down.
Okay, so the carport is actually an L-shaped configuration off your garage? Because the way it looks on here is-
Yes, it's right off the garage.
Okay.
Yeah.
So it is within the easement currently, though, the 33-foot? It's
Within the 33-foot, but I'm going to take it down
Okay.
once we build the other part of it. There's
Okay.
not, it's just, yeah, it's a carport and a boat's under there.
Okay, thank you for clarifying.
Thank you, Mr. Jones. Do we have any other questions? Seeing none, we're now going to open up the hearing to public testimony. Is there anyone wishing to testify? Yep. Good. Seeing none, Mr. Hepler, would you like to come back up and give any closing statements? I think I'm good, thank you. He indicated no for the record. Are there any further questions of staff or Mr. Hepler?
I have just one question through the chair. Out of curiosity, if a road was ever to be placed on BLM reservations like this, what entity would do that? Who would plow a road and make it exist?
Through the chair, Mr. Merca, in this area, it's not DOT, it'd be the municipality who would be the one who'd, yeah. And like Dr. Hepler said, the lot to the west of his current lot, they vacated the 33-foot many, many years ago by platting action.
Thank you.
And why it didn't happen in 2013 when this was originally platted, I'm not exactly sure either.
Yeah. Thank you so much.
Thank you, Mr. Merca. Any other final questions?
Through the chair, I have one question for staff.
Go ahead.
I was just wondering if the department recommendation for approval needs to be updated to indicate removal of the carport prior to the vacation.
Through the chair, Ms. Butler, no, because it's not related to the plat in that sense. That's a building permit land use question, and we don't. Mr. Hepler's going to remove it as he stated when he goes in through for his building permit, because they won't let him keep it and continue on with this. So he's being proactive in taking this action first.
Perfect. That's great. Thanks.
Thank you for that question and answer. Any other questions? Seeing none at this time, I'd like to close public testimony, or the public hearing, sorry. Do we have a motion? Moved by Mr. Cross, seconded by Mr. Jones. Mr. Cross, can you state your motion?
I move in case S12807 to approve the vacation elimination of a 33-foot BLM reservation for the roadway recorded by Book 93, page 95, along with the west property boundary, subject to the conditions shown on page 5 of the staff report.
Thank you. Would you like to speak to your motion?
Yes, there are 6 provisions of which a BLM easement should be removed. They're located on page 4 and 5. All 6 of those should be met. I would also like to add, I feel so bad for the petitioner that he had to go through all this for something that just seems so blatantly obvious. This is part of the things that makes me just want to beat my head on this table. Sorry it cost you so much money. I'm sorry you have to remove your carport, because if anybody looked at your lot and how it's laid out, it's really doing nothing other than an imaginary line that's been drawn in the sand that somehow is beyond being detrimental to you. I'm sorry you have to go through this, but I'm glad that I'm here today to help you resolve it. Thank you.
Thank you, Mr. Cross. Mr. Jones, would you like to speak to your second?
Yes, thank you. I would concur that it meets the criteria listed out in the staff report. And additionally, just wanting to shed some light on the comment that was received there and then the clarification by staff that the removal of this would not impact or provide any assistance to the East 112th comment. So I do intend to support this motion. Thank you.
Thank you, Mr. Jones. Does anyone else have any findings that they'd like to add to the record?
Through the chair, I would just like to add that this BLM reservation easement, it's not a classified road and isn't access of all future needs, so I fully intend to support this motion.
Thank you, Ms. Butler. Any other findings that anybody would like to add? Seeing none, let's call the vote.
Ms. Butler, how do you vote?
Yes.
Thank you.
With that, 6 yeses, 0 noes, the motion passes. Okay, staff, would you like to present your case? Oh, sorry, actually, we do need a second motion. Do we have a motion? Yes, we need a second motion for the 24-month plat. Do we have a motion? Moved by Mr. Cross, seconded by Mr. Jones. Mr. Cross, can you state your motion?
I move in case S12807 to approve the plat for 24 months, subject to the conditions shown on page 5 of the staff report.
Mr. Cross, would you like to speak to your motion?
No, you can just reference the record for my comments regarding the previous action. Thank you.
Thank you, Mr. Cross. Mr. Jones, would you like to speak to your second?
I would mirror Mr. Cross's comments for that.
Thank you, Mr. Jones. Anybody else have any findings that they'd like to add to the record? Seeing none, let's call the vote.
Ms. Butler, how do you vote?
Yes.
Thank you.
With that, the motion passes 6-0. Staff, would you like to present your case in, or can you start your presentation in case S12814?
Yes, Mr. Chair, let me grab that. We have a few of them before us tonight. Yes, okay. 814. Okay, so this is a request to remove plat notes number 3 and number 9 from plat P386, which is the Wentworth subdivision, block 2, lot 17. And the purpose of the petitioner's request is to allow the owner to secure financing for the remodel of an existing triplex. The petitioner's request to remove those plat notes as the structure would conform to current Title 21 dimensional standards. The original plat back in 1954 placed use and dimensional standards at a time prior to municipal zoning regulations that took effect in 1970. So the code requires a minimum of 6,000 square feet for up to 4 units. The lot size is 8,000 and they have 3 units. The side setback requirement is 5 feet. However, the structure has non-conforming rights for the east side corner being 4.7 feet from the property line. So staff analysis for the request to remove them. The conditions that required the plat note have changed because the protections established by residential district standards by Title 21, such as setbacks and minimum lot dimensions. At the time of the plat and construction, 1954, plat notes afforded protections in the absence of land use regulations. The structure has non-conforming rights for the side setback, and the need for the plat notes have been negated as there is a current code for the residential district dimensional standards. Staff finds B has been met. Modification of the plat notes will not have a negative effect on neighboring properties. Removal of the plat notes would not reduce protection of the setbacks and lot dimensions or apply a less restrictive code to the property. Staff finds that condition C has been met. Plat P386 will continue to meet the approval criteria for subdivisions if plat notes number 3 and 9 are removed. The existing subdivision still facilitates the orderly, efficient layout and use of the land, even without the restrictive plat notes. There was no objections to removing these plat notes from any of the agencies. Staff finds because of that, we recommended approval depending on conditions A1, and then which is just the removal of those plat notes recorded in resolution, and then 2, which is the traffic engineering does say if it gets approved, they need to reduce that width of the driveway down to no wider than 40% of the lot, or 24 feet. So this was an interesting one as they came to the counter. They've got their non-conformity determination, and it was a case of they had gone in for financing to upgrade their triplex, but this plat note was restricting a lot of things that current code today allows them to do. So we basically said, well, just remove these plat notes and conform to today's code, and everything will be okay. And hopefully you can go get your financing still. So that's kind of the background on that. I'm happy to answer any questions, and we have Clint here. He can answer some. He's the petitioner as well. Thank you.
Thank you for that presentation. Do we have any questions of staff? I see Mr. Jones ready.
Thank you. I would like to just ask for clarification that tonight we are only looking at the request to remove the plat notes 3 and 9 and not looking at the encroachment on the side yard. Less than that, that would be a different board to look at that if they were looking to do any improvements to their exterior of their house that would impact.
That is correct. Yep, we're just here for removal of 3 and 9, and then that sets everything in motion.
Thank you. Additional question on that would be kind of similarly with that non-conforming item there with the side setback, would the driveway not be kind of that same type of thing that it would just be impacted if they did some exterior work? I'm concerned why that wouldn't be included in the write-up versus if they do exterior work.
Yeah, through the chair. So if we turn to page 21, let's take a look there. This is the non-conforming, verification of non-conforming status is a technical term there. And we can see about halfway through the page, it says the driveway design standards were in effect after 83. It says the driveway is not a legal non-conforming character of use and is in violation. So the verification status had determined that the driveway width like that probably was built when there was a time that you weren't allowed to build it that wide. So therefore, yeah, if they're going to come in for a permit and stuff, they're going to have to do something with the driveway.
Okay, thank you for clarifying the difference between those.
Thank you for those questions. Do we have any other questions of staff? Seeing none, I think we're ready for the petitioner's presentation. please state and spell your name for the record?
Clint Earns, one of the owners there at the property. Pretty much the staff pretty much laid out the thing. With the driveway, we went through traffic when we did the remodel and all that, and they said not to get, we did have to remove part of the pavers because those pavers were part of it to get to it, so it passed through traffic. But they're redoing that road next year or something like that, repaving that whole thing, so they said not to do anything with the driveway until they pave it, for the driveway portion of it. That's about all I got. We're trying to just get those plat notes removed so we can refinance and get our money back.
Thank you for your presentation. You have if you'd like a few more seconds because the clock was stopped a little late.
No, I'm good.
Okay, you have 9 minutes and 18 seconds left to rebuttal.
All right, thanks.
At this time, we're going to open up to public testimony. Would anyone like to testify? Seeing none, would you like to come back up and use your remaining time? Do we have any questions of the applicant? Seeing none, we are going to close the public hearing. Do we have a motion? Moved by Mr. Merca, seconded by Mr. Jones. Mr. Merca, can you state your motion?
I move in case S12814 to approve the removal of restrictive plat notes number 3 that states buildings on other than business lots shall not be constructed or placed within 15 feet of the front boundary line of lot or within 5 feet of any other boundary line of the lot, with this exception, that a garage may be placed within 2 feet of the rear property line, and plat note 9 that states maximum of 2 buildings to a lot, only one of which may be used for habitation. All living units, whether single or duplex type, must be under one roof. Maximum of 1 two-family dwelling on each lot plus garage, subject to the conditions shown on page 3 and 4 of the staff report.
Thank you, Mr. Merca. Would you like to speak to your motion?
Yeah, I'll speak to the motion. As staff has already very clearly stated, these 2 plat notes were at a time when we didn't have the acreage code that we have, which makes these completely irrelevant. So I'll be supporting the motion.
Thank you, Mr. Merca. Mr. Jones, would you like to speak to your second?
Yes, thank you. I would agree with Mr. Merck. Obviously, based on the age of the property, these were put in place in lieu of Anchorage Municipal Code, so now we have that. No need for these, so I will be supporting it. Thank you.
Thank you, Mr. Jones. Mr. Cross, would you like to add findings?
Yeah, just regarding the driveway width and the non-conforming, I have verified through the Anchorage Metropolitan Area Transportation Safety Board official streets plan that that the Piper Street road improvements are in fact on the book. So the petitioner was not blowing smoke. That is a proposed road project in the works. Thank you.
Thank you, Mr. Cross, for looking that up and confirming. Would anyone else like to add findings?
Through the chair.
Yes, Ms. Butler.
Yeah, I would just like to find, so I'm going to be supporting this motion for sure. The driveway width has been addressed to conform with Muni Code. No reviewing agencies objected. There's been no public comments, no community council comments. This plat has a legal non-conforming determination. Removal of plat notes 3 and 9 will negate current code violation status, and this meets the requirements of 2103 200 G9 A to C with the non-conforming. So, that's all.
Thank you, Ms. Butler. Would anyone else like to add any findings? Seeing none, let's call for a vote.
Ms. Butler, how do you vote?
Yes.
Thank you.
With that, the motion passes 6-0. Staff, would you like to prepare your presentation? Sorry, we need a second motion for the plat, 24-month plat, moved by Mr. Merca, seconded by Mr. Jones. Mr. Merca, would you like to state your motion?
I don't think the motion is stated correctly.
Sorry.
We're all excited to get to that one. Wait reading. That's not it either.
We're just dealing with technical difficulties. Just waiting on stuff to load. Appreciate your patience.
We're now ready to hear staff's presentation in case S12810.
Thank you, Mr. Chair. So this one is a request to subdivide 4 lots into 6 lots with a variance from AMC 2108-050C. That's improvement requirements by improvement area. So the subdivider is seeking relief from Class A design standards to not construct vertical curb and gutters, sidewalks, and continuous street lighting. The proposed improvements would match the existing road improvements on Zeus Circle and provide a new single street light. The request is being made to allow for 2 additional residential lots within the subdivision, and it's going to match what's right there that was just recently constructed a few years ago all along Zeus Circle. So the subdivider is also proposing a single new street light. However, they have to apply for that variance for continuous street lighting. It was a common theme here with the approval criteria. We'll get into those approval criteria. Staff finds criteria A has been met. It would be impractical to build sidewalks or curb and gutter drainage infrastructure where the neighborhood drainage system was not designed to support it, and the traffic department, private development, and right-of-way support the requested variances with a requirement to install 1 street light. Staff finds condition B has been met. The variances will provide a road to be built for the subdivision that both adequately serves the neighborhood and allows the cul-de-sac to match the existing improvements on Zeus Circle. Criteria C has been met. The construction of Zeus Circle will still be subject to a subdivision agreement with improvements matching the rest of the existing street. This will just be a continuation with a new cul-de-sac. Staff finds condition D criteria has been met. Strict compliance with the requirements would create undue hardship as the number of lots created would not be proportionate to full street standards. Strict compliance of the regulations would not be financially feasible for the development of the subdivision. Once, just to recap, they're subdividing this 4 lots into 6 lots now, and they all meet the minimum lot requirements and dimensions of the R1 single-family zoning district. And it'll be a continuation of what's already just recently built out there with them adding that 1 street light, which they're amenable to. So staff recommends approval of condition A, and then the second B it's misnumbered in the staff report, but it's A 1 and 2, and then B approval of the plat subject to 1, 2, 3, A, B, and C. That's it. Thank you.
Thank you for that presentation. Do we have any questions of staff? Mr. Jones.
Thank you. Would you be able to shine some light on why the Zeus Circle development wasn't built to, the sidewalks and curb and gutter, and then obviously with this one being requested to match that. But I guess my question is why that original development wasn't built to those standards?
I believe I might rely on the surveyor record here, but I believe a couple years ago we went through the same process to not same thing for curbs, sidewalks, and gutters, and that was to match even further back the rest of the entire neighborhood that is all strip paved. And then they put I believe they put a street light in, but it's the same. They got a variance from that as well previously.
Thank you for clarifying.
Thank you, Mr. Jones. Any other questions of staff?
To the chair, I have a question for staff. Go
ahead, Ms. Butler.
It's actually more just of a clarification. I was reading through AMC 2108-050I with street lighting, and it obviously says, that the street lighting apparatus shall meet municipal standards and locations and stuff. But it says that it shall comply with the standards contained in the design criteria manual. But the design criteria manual, section 5.2D, design variances, it states that written variance requests shall be prepared and submitted through the muni project manager or private development coordinator for determination by the traffic engineer. My question is, it's kind of like why we are deciding on a lighting variance when it's not actually a variance to remove the lighting requirement. It's a variance to reduce the amount of lighting as outlined in the design criteria manual. That's my question.
Correct. Yeah, traffic does weigh in on that, but yes, it's kind of just the way the code's written. They have to apply for a variance to not for no lighting, but yet they're agreeing for one light, and that's kind of we went back and forth. I believe the survey and the engineer of record met with traffic and private development and discussed all this kind of post or pre-app and before the application was submitted. But our code says yes, if traffic's amenable to a reduced lighting standard, our section of 08 says you have to apply for this variance to no lighting. But then they turn around and they're going to provide one street light, which traffic is fine with. They've determined that that's kind of what needs to be out there. It's a reduced standard. Yeah. Does that answer your question?
Yeah, it just seems it just seems like kind of unfortunate back and forth that doesn't really need to happen, but I just wanted some clarification on that. Thank you.
Yeah, they agreed to it, but there's nothing in code that says there's like a variance to a reduced standard or that we have the ability to reduce that. They have to go through this process.
Okay, thanks.
Thank you for that question and answer. Any other questions of staff? Seeing none, we are ready for the presentation.
Good evening. Through the chair, members of the board, my name is Tony Hoffman. I work with the Boutte Company, and I'm here on behalf of the owner and the developer of the property, Merritt Homes. With me tonight is the engineer of record of Triad Engineering, Brandon Marcotte. First, I'm going to keep this brief because we have two other cases tonight, and I really want to get through everything. So, to discuss the subdivision, it's a pretty straightforward subdivision in and of itself, where these lots that we've designed are still larger than R1 lots. And the reason I believe that they platted them so large in 1972, one of the main reasons is this was classified as a wetland in 1972, and since then. Right now, the developer is through a wetlands consultant. This parcel has been, since 100th got built and the rest of the area has been developed, it's become an isolated piece of wet, and it's not a jurisdictional wetland. So that's why we can develop it now, because it's been sitting there for a long time. And Merritt Homes has owned it for a while, but until we really wrapped our minds around this wetland and what we could do with it, and we got the analysis and the Corps of Engineer determination, we couldn't really do anything because it's a difficult piece of ground to develop if it's all wet. Now it's a flat piece of ground and it's draining constantly, and it's not as wet as it was. So there's no water flowing in and out of it. It's an isolated wetland. So it's perked down, it's permeated, it's a good piece of ground now. So what's always held it back is the access into Zoo Circle. Even though it was platted in 72, it never got built. The reason we're asking for the variance, to speak to that, is pretty obvious. It was strip paved. The whole development since 72 has been, the Platting has been built out with 50-foot right-of-ways and strip paved roads. In a 50-foot right-of-way, you start running into problems building a full-width curb and gutter road. And that's one of the reasons we're requesting this variance, other than the fact that it matches the rest of the development. So that's why we're doing this. It's a step that we have to take. But no curb and gutter will match the rest of the development, and it has been proven in this development that no curb and gutter works fine, because with the large ditches and a fairly non-dense development, even though it's R1, it doesn't create a lot of water drainage. It's not nearly as much as a much denser 7,000-foot subdivision or an R2 subdivision or something. So that's why we're requesting that variance. Now, as far as the lights go, the question that Ms. Butler had about the lights, that's a very good question about this process. But we have to go through this step because the requirement for the development standards is in 2108. So the only venue we have for applying for variance in 2108 is through this process, a variance for the subdivision standard. So that's what we're doing. But during that process, while the departments are reviewing the variance request, all the agencies weigh in on it. And if you look on page, it's on page 61 of your package, private development has agreed in our request. I mean, install one street light. So it is a little more spacing between the street light at the intersection of the bulb down there and us at the end of the cul-de-sac is 300 feet. Usually they require them about every 150 feet. But this keeps in the character of the subdivision. And there's a lot of ambient light that's falling off of the street lights on 100th as well. So additional street lights are not really always desirable, especially in an R1 development that's been kind of built in this fashion. So that's the reasoning for the request. That's really all we have about this. This is a pretty straightforward subdivision. We did a lot of design work looking at it. All these lots meet the 3-to-1. You know, there's no need for 3-to-1. They look narrow, but actually they're very nice, large lots for an R1 area. So they're 10,000, 9,000 feet. So they're pretty good sized lots. Other than that, I'll reserve my time for any responses.
Thank you for that. Do we have any questions for the petitioner's representative?
Okay.
Mr. Jones.
Thank you. I got a couple questions for you here. So if the Corps of Engineers determines that it's not wetlands that's out there or doesn't meet the criteria for it, what would be, or can you speak to the process of how that ground would be then remediated or removed, or if it would be?
Absolutely. I have just the person. This is Brandon Marcotte. He's the engineer.
Yes, Brandon Marcotte with Triad Engineering, last name's M-A-R-C-O-T-T. If the Corps confirms that the ground is non-jurisdictional, the wetlands, we would permit through the planning department. There is an application in the works with the planning department for developing non-jurisdictional wetlands. So we'd basically fill them in, build the road, and install the utilities back into the cul-de-sac.
Thank you. Second question that I had might be better directed towards you. I did not see, it was mentioned in here about a walkway that would connect to 100th, but I did not see that, unless I just completely missed it, on any of the plats of where that walkway would be and what between what lots it would lie on.
Through the chair, Mr. Jones, that walkway would be between lots 18A and 18B. So that would extend from the bulb and zoo circle kind of in a southwesterly direction and tie into the existing sidewalk on 100th Avenue. It's a requirement in Title 21 that cul-de-sac bulbs be connected with pathways whenever possible. This is about as close as you can get to another road that also has a sidewalk or a pathway, so a variance or a request not to build wasn't really reasonable in our opinion.
Perfect. Okay. That's where I assumed it would be, but appreciate the clarification. Thank you.
Thank you for those questions. Anyone else have questions? Seeing none. This time we'd like to open it up to public testimony. Anyone wishing to testify? Not seeing any public testimony. Would you like to use your remaining time for rebuttal?
No, thank you. Thank you.
Thank you for your presentation. Do we have any final questions? Then we're now going to close the public testimony. We will need two motions on this. Does anyone have a motion regarding the variance? Moved by Mr. Murka, seconded by Mr. Cross. Mr. Murka, can you state your motion?
I move in case S12810 to approve the variance from AMC 21.08.05C, improvement requirements by improvement area from vertical curb and gutter, sidewalks, and continuous lighting subject to the conditions shown on page 5 of the staff report.
Thank you, Mr. Murka. Would you like to speak to your motion?
Yes, I think that all of these conditions, criteria from A through D have been met, and I agree with the variances that are proposed. I'll be supporting the motion.
Thank you, Mr. Murka. Mr. Cross, would you like to speak to your second?
Yes, just pointing out in staff packet, pages 4 and 5, that there are 4 criteria required for approval, and all criteria has been met. Regarding the new single street light that's in there, it's important to note that this new street light is only 152 feet away from 100th Avenue, which is a well-lit, established street. So it would make sense that the ambient light created from that would be sufficient with one additional street light for the intersection. Thank you.
Thank you, Mr. Cross. Would anyone else like to add findings?
I have additional finding or note that I could add for the record here. So this is kind of a good example of some of the difficulty we have with this particular board, in that the comprehensive plan that's kind of our guiding light on this is pretty clear that we're trying to make new developments have sidewalks and some of these other features that are important to folks that live in Anchorage. But with obviously this development the way it is, it's very clear it would be impractical to impose that on this very limited development. And obviously with the development that was done next to it and tying to an additional property that's been built for years, these are kind of the infill developments that we have to work with, and they're kind of difficult to hold that and do those sidewalk requirements when there's really nowhere to go with them. But I do feel like this property is taking into consideration the walkway to 100th. Obviously, that's a requirement, and I think that'll be a nice feature for the folks that live in this area. I intend to support this motion. Thank you.
Thank you, Mr. Jones. Anyone else like to add findings? Seeing none, let's call the vote.
Ms. Butler, how do you vote?
Yes.
Thank you.
With that, the motion passes 6-0. Do we have a motion regarding the plat? Moved by Mr. Merca, second by Mr. Jones. Mr. Merca, can you state your motion?
I move in case S12810 to approve the plat for 24 months, subject to the conditions shown on page 5 and 6 of the staff report.
Thank you, Mr. Merca. Would you like to speak to your motion?
Yes. My mind totally went blank. I find that all these conditions are met. So I will be supporting this motion.
Thank you for those thorough points. Mr. Jones, would you like to speak?
It is late, Chairman.
Thank you. Yeah, I think the department did a good job in summarizing the needs that we would have here. I have nothing further to add other than I would support this motion. Thank you.
Thank you, Mr. Jones. Would anyone else like to add findings?
Yes, I'd like to put some thoughts on the record.
Go ahead.
Just wanted to, again, say that this is actually already a partially developed cul-de-sac, so the associated platting action is a continuation of a development. So it fits in the area and the build as is. No reviewing agencies objected to this action, and they're not asking for anything that isn't conforming to what is existing.
Thank you, Ms. Butler. Would anyone else like to add findings? Seeing none, let's call the vote.
Ms. Butler, how do you vote?
Yes.
Thank you.
With that, the motion passes 6-0. Staff, can you prepare your presentation for case S12811?
Thank you, Mr. Chair. So this is a request to subdivide 3 lots into 3 lots, basically just a realignment of some lines on the ground. They are applying for a variance, though, from lot frontage and access that all lots shall have frontage onto a street. So this request is being made, like I said, to allow the owners to reconfigure their lots. The request, the variance is being made as Government Lot 2 is an original unsubdivided lot that was not part of the platting actions creating the Discovery Heights subdivision. Government Lot 2 has historically been without frontage to a street, and physical access to this lot is granted by a 40-foot wide access easement across the Lot 11. So staff, in findings of this variance, first off, the petition site is surrounded by PCD Community District. The proposed lots meet the minimum lot size and width required by the zoning district. There is an existing shed on proposed Lot 2A. It should be noted that accessory structures are not allowed without a primary principal use of a single-family home, and the owner can resolve this by moving the shed to a conforming location on one of the lots. So we'll get into the matters of the variance request. Staff finds condition A has been met. The proposed subdivision keeps the intent of the original subdivision. There are some special circumstances for that strict application of the subdivision regulations would be undesirable. Government Lot 2 was created without public access to rights-of-way. As the property was not transferred to private ownership until 2000, it was not included in the development of Discovery Heights subdivision, and no legal access was provided. Traffic Department, private development, and right-of-way support the requested variance. It would be undesirable to require right-of-way to the lot as the recorded easement provides physical access. Condition B has been met. The current use, ownership, and access for the properties will not change by allowing the variance. Physical access is provided to the vacant lot through a recorded access easement and is enjoyed as yard by Lot 8A. Condition C has been met. It will not have will not have the nullifying effect of the intent of the subdivision standards. There's no additional residences proposed, creation of additional lots with this plat in action. It's just a lot configuration that's keeping with the intent of the subdivision by moving some of the lines. Condition D, staff finds that has been met. Strict compliance with the requirements would create undue hardship, as a requirement to provide dedicated right-of-way to the lot would require purchasing property or re-subdividing adjoining lots. The variance to the street frontage is the minimum variance necessary for the adjustment of the lot lines. As stated, there is physical access to that lot. Staff finds condition A, or staff finds that the variance request should be approved, subject to conditions A and B found on staff page of the staff packet. So if we turn to page, basically 9 is probably the best look at that. That government lot was a leftover piece, as you can see, out of that whole entire large rectangle. The whole entire South Port or South Bluff area there was all subdivided in various plats, and then that piece there that you can see was picked up in 2000 by the owner, and he included his neighbor there, and that's what we're here tonight, is they're basically just kind of changing some of the lot lines for that. I'm happy to answer any questions, and the surveyor is here as well tonight. Thank you.
Thank you for that presentation. Do we have any questions of staff? Mr. Murka.
I think you just said so, but Lot 2 has been acquired by the Stanleys, is that correct?
Yes, that is correct. Yep, they acquired that, and now we're kind of just reconfiguring some of the lines with his neighbor.
Perfect. Thank you.
Mr. Jones.
Thank you. This is kind of it's an interesting piece of property here and how this kind of came to be. I guess, just out of curiosity, do you have any backstory as to how this just like eventually kind of became now part of this development or was able to be purchased? But I mean, why wouldn't it have been included much earlier, I guess?
That I'm not sure. That government lot 2 was just, they never, with the development of the original subdivision for Discovery Heights, they never were able to purchase that, and the current owners, they somehow worked out with and was able to purchase it. Surveyor may have a little more knowledge of that, but yes, it is kind of interesting, but that's why we're here tonight, because they did purchase it. Now they're trying to kind of fold it into the mix.
Thank you. Additional comment that I have for you, we did get this late public comment on this one here, and that concern of the Discovery Heights Association, which is referring to when this changes any of the lot identification with the city and the association documents. Would this, if we approve this and move forward, would any of this be covered as part of the things that are part of the department recommendation, or would these things be something that would have to be additional above and beyond for either the petitioner or someone else to try to chase down, or how would this get tracked properly?
Through the chair, yeah, Mr. Jones. So, yeah, we're going to hear testimony tonight, and we have the written comments in front of us. That's kind of a civil issue. It's the homeowners association and the property owners. There's nothing in the subdivision code for a subdivision that requires the municipality for homeowners associations. Those are kind of like a civil issue between the owners. I imagine they would update it as requested. We're not creating any new lots, so to speak, tonight. We're just rearranging the lines in the sand.
Okay, thank you for clarifying.
Any other questions of staff? Seeing none, we are ready for the petitioner's presentation.
Good evening. Through the chair, members of the board, my name is Tony Hoffman. I work with the Boutte Company, and I'm here to discuss this replat of Discovery Heights and that U.S. government lot. It is a fairly straightforward event until you really drill down into it. So I'm going to keep this quick, but basically we have two parties involved, Lot 8, the owners of Lot 8, 9, and the U.S. government lot. So the Stanleys own Lot 8 and then the U.S. government lot. Lot 9 is owned by a different party, the Barretts. So what they're doing here is Mr. Stanley on Lot 8, he overbuilt a little bit. So we're helping, part of the reason this plat is to help him become compliant with the rear setback. That's one thing. Because he owns both lots, 2 and 9, it never was an issue, it never came up, and it's not a problem really. But whenever you come in for a new permit again, it's going to become a problem. So we're helping him fix some issues and kind of trying to just create 3 better lots, I guess. I want to talk about Lot 2 a little bit. It is kind of an interesting thing. The lot came into being it actually got bought by the Mental Health Land Trust, or it became owned by the Mental Health Land Trust from DNR in 2000. And it's a remnant parcel, and the deed is kind of odd. It reads that the western extent of that Lot 2A it extends down to the 20-foot contour line. So it's never really been platted that way. So that's why if you look on the right side of the page at our proposed configuration, it enlarges the lot out. And it went to the 20-foot contour line because that's the time that they were really considering the trail down there, the coastal access trail, we'll call it. And it fell. The idea was they were going to build that between the 20 and about the 10-foot contour line. So the parcel, the end of this parcel, the way they deeded it, they couldn't exceed down below 20 foot. So they had room to build the trail. So that's why it reads that. So when we replat this, we have to extend that property line out to the 20-foot contour line. It's giving him a little bit of extra line, but that's why it looks kind of odd. If you look how the new lot 9A is being configured, it goes down because it's following that quarter section line, and it intersects the 20-foot line. It is kind of a weird thing, but that's just about the lots and how that Lot 2 came into being. It really didn't exist when they were platting, legally, when they were platting Discovery Heights in '97. They did this phase. And that lot wasn't owned, or wasn't even on the market. It wasn't available for sale until 2000. And then the Stanleys snapped it up because it was right behind his house. And I don't know how they did it, but they got it cheaply. So it's a wonderful lot. So he's trying to create, he's trying to fix some problems and just reconfigure the lot with his neighbor next door and just kind of enlarge the lots and create this new Lot 2A. So they're named Lot 8A and 9A on the new land of Discovery Heights, and then Lot 2A, because we're not going to include Lot 2A into the homeowner association. It's not going to be part of it. But 8 and 9 are getting renamed to 8A and 9A. And that's where this issue with the homeowner association comes. The only change in the homeowner documents is going to be the name. It's going to be lot 8A and 9A instead of lot 8 and 9. But it is kind of a housekeeping thing that has to happen, and it will happen. But it's a civil issue between the homeowner association and the homeowner. So unless there's a plat note or some extenuating circumstance, it's not something that the board can, or the planning department can really regulate. But you know, it's one of those things that does need to be done, and this is such a large development. The owners have agreed that, you know, they need to update the documents. They need to be part of that process. So they have agreed to that, but it's not really a platting condition that we can deal with. So that is a private issue. Now, in regards to the access variance, I think that's a pretty straightforward request. When Mr. Stanley bought this property in 2000, immediately afterwards in 2003 is when he got that that private access easement to the north up through lot 11 and 5. So it's a built access actually, and it's gated off, but it's a nice access. So he's got legal access. He just doesn't have physical or legal access that planning would consider legal and physical. That's why we have to ask for a variance. But if he could never improve the lot to a, you know, he couldn't subdivide it until he had a legal right-of-way. So there's no development that's going to occur in that until that's resolved. But by getting the variance, that gives us the variance so we can create this parcel of land that's still removed from right-of-way. But, you know, you can't build it out because there's no legal access yet. But the variance allows us to plat. Now, the only other comment I'm going to make tonight, I want to point this out to the board. So there's, Mr. Stanley has a shed on U.S. Government Lot 2. And this was one of the big issues because code says it's not legal. Even though he owns a parcel and it's just a single structure, because there's not a habitable dwelling on that lot, it's not a legal accessory structure. That's the only reason they're making him remove it. And I'm telling you, I think that is a wrong rule. And when we got into this, probably around November, Assembly had an ordinance that they'd brought forward. It dropped. But no one, I don't know if staff has kind of followed up to find out why it dropped, but that's one of the reasons we just went full bore on this. So we're still going to have to deal with that because it's a condition on the plat, or on the requirements. I just think it's wrong. I mean, the guy's just using it as a shed, just because he doesn't have his house on that lot. And the only reason it's really coming up is because we're replatting it. But we're not, you know, it's just because that's an existing condition. That shed's been there for years, and now all of a sudden, he's been contacted by the Muni about a violation. There's and now he's going to have to move it. Just because it's a shed on his large lot, he's going to have to move it. So it's not a good rule. That's all I'm going to say about that. I can't object to it because staff says it's in code and we can't remove that condition. I'm bringing it up to your attention. So with that, I'll reserve my time.
Thank you for that. You have 2 minutes and 25 seconds of rebuttal time.
Thank you.
Do we have any questions of the petitioner? Sorry, Mr. Murko.
Mr. Hoffman, I'm curious about the access that comes into Lot 2 now. Both sides of this, so Lot 2 where it's accessing and the new lots 8A and 9A,
right,
they're all in the Discovery Heights Homeowners Association. Is that correct?
Lot 8 and 9 are currently in the Homeowner Association. U.S. Government Lot 2 is not.
How about access to Lot 2?
Okay, so that's that private access. That's the only access he has.
Correct.
And he got that from the owners of those lots, so he could use, you know, it's a paved little access road with a gate, and that's so he could use this lot too, because he can't drive through his lot off of, you know, South Bluff Drive or Circle. So that's his access into it, so he can use that. And it's a private access. It's a little strip paved road, but it works great.
And I think my follow-up to that is, Could Lot 2 apply for a building permit and build a home on Lot 2?
Now, that's a very good question because it doesn't have necessarily a right-of-way access. Sean, I'll defer to staff.
Well, through the chair, that usually subdivisions have legal and physical access. This has physical access through that recorded document, through that access easement. And yes, if you applied for a building permit, you would just have to prove or show that there's that recorded document with the access across.
That makes sense because we're not replatting. We wouldn't replat it. We couldn't replat it without a legal right-of-way. But he could put a single structure building on a habitable structure. Yeah. And, that may be his plan, but it's a beautiful lot. You got to go out and look at it.
Yeah. Yep. Thank you.
Mr. Cross.
Yeah, Mr. Hoffman, just real quick, give me the information of the individual in code enforcement who's getting you to remove that shed, because this is ridiculous. You get it for me, and we'll deal with that at the next CDC meeting. Thank you.
I'll let staff dig that up too. It wasn't very well identified in the package, but it's there somewhere. We were hoping the assembly ordinance would get passed, so.
Any other questions? Seeing none, we're now going to open up to public testimony. Are there any members of the public that would like to testify? Please come forth and state and spell your name for the record.
Good evening, members of the Platting Board. My name is Margaret Louie, and I'm the president of Discovery Heights Owners Association. I'm here to express our association's position regarding the proposed replatting of 2 bluff lots within our community. The 2 property owners in question have collaboratively addressed encroachment issues arising from structures built over the past 25 years. They have conducted new lot line surveys and mutually agreed upon a reconfiguration that resolves these encroachments. We recommend we commend their proactive approach in settling this matter amicably while all parties familiar with the situation are present. The Discovery Heights Owners Association has no objections to this replatting, provided that the following conditions to which the appellants have already agreed are met. Financial responsibility. The appellants will bear all attorney's fees associated with replatting the 2 lots and making necessary modifications to our HOA's declaration to reflect the new lot numbers and legal descriptions. Legal review. The revised documents will be submitted to our Homeowners Association attorney for review to ensure their sufficiency. Recording of the documents. Upon completion and approval, the updated HOA documents must be recorded with the municipality of Anchorage, with the appellants covering the recording fees. We believe these conditions are reasonable and ensure that the replatting process aligns with our association's governing documents and municipal regulations. We respectfully request that the Platting Board incorporate these conditions into their approval of the replatting application. Thank you for your time and consideration.
Thank you for that testimony. Does anyone have any questions of the testifier? Seeing none, would anyone else like to testify? Seeing none, we are on to rebuttal, and
I'm missing 35 seconds.
Go ahead.
Perfect.
Wait 1 second.
Okay.
Okay, go
There.
ahead.
Through the board, or through the chair, members of the board, the owners have talked with the HOA board and they have discussed this. Tentatively, they have agreed to modify the documents to reflect the new names of 8A and 9A or 8 and 9 to 8A and 9A. It's not, I don't think, and I think staff would agree that it's not in the purview of this board to add that as a platting condition. However, and it is it's a legal private issue. It is still something that I can say that the petitioners have agreed to tentatively. Now, how it works out in the end, I can't guarantee. It's not something that, is part of this platting action. It was part of the underlying platting action, but it's not. The modifications of HOA are kind of in a gray area, and we've gotten into a lot of that tonight. So I'm going to just leave it at that. I think that it is a civil issue that needs to be handled out of this room. Other than that, I have no other rebuttals or comments.
Thank you. Do we have any final questions for the testifier or for the petitioner? Seeing none, let's close the public hearing.
Thank you.
Do we have a motion regarding the variance? Unsurprisingly, moved by Mr. Cross and seconded by Mr. Jones. Mr. Cross, would you like to state your motion?
I move in case S12811 to approve the variance from AMC 21.08.030L1, lot frontage and access. All lots shall have frontage on a street, subject to the conditions shown on page 5 of the staff report.
Mr. Cross, I assume you'd like to speak to your motion.
Yes, again, just referring back to the staff packet on pages 4 and 5, the criteria that must be met in order for this change to take place. Regarding, and it's also just important to realize that all we're doing is moving property lines. I mean, functionally, the impact is minimal since the petitioner owns both lots and effectively has been using them as if it's own lot anyway. The one thing important is that we don't get into civil matters. Matters of HOA are private party agreements and are not privy to the authority of the platting board. So although I understand the HOA's concerns, that is not an area of which we have authority. So thank you.
Thank you, Mr. Cross. Mr. Jones, would you like to speak to your second?
Thank you. I would agree with Mr. Cross's summation on that, and would also add that, I feel like the property owner's done what they can in their ability to provide with the private access on the other side, and also would note too that mirroring what Mr. Cross had said, I feel like the department recommendation has a good summary of the things that are in our purview to look at, and obviously the civil components that were brought up by the HOA would not be something that we would be able to add to this, but I do hope that that's something that's remedied between those parties. Thank you.
Thank you, Mr. Jones. Would anyone else like to add findings?
Yes, through the chair.
Yes, go ahead.
I would just want to make sure that it's on the record that this variance will grant access to government lot 2 that was landlocked with no legal access, and that this platting action with the variance does not create lots, provides access to all 3 lots, and the configurations are keeping with the intent of the subdivision and the comprehensive plan designation of single-family dwellings. Both of the petitioners, which are neighbors, it's great that they're working together and are in agreement for this platting action with variance. So that means that the action and variance will not have a negative impact on the adjacent properties.
Thank you, Ms. Butler. Would anyone else like to add findings? Seeing none, let's call the vote.
Ms. Butler, how do you vote?
Yes.
Thank you.
With that, the motion passes 6-0. Do we have a motion regarding the plat? Moved by Mr. Jones. Second by Mr. Cross. Mr. Jones, can you state your motion?
Yes, I move in case S12811 to approve the plat for 24 months, subject to the conditions shown on page 5 of the staff report.
Thank you, Mr. Jones. Would you like to speak to your motion?
Thank you. I'd like to just defer to the comments that were provided for the previous motion.
Thank you, Mr. Jones. Mr. Cross, would you like to speak to your second?
No additional comments, Chair. Thank you.
Thank you, Mr. Cross. Would anyone else like to add findings? Seeing none, let's call the vote.
Ms. Butler, how do you vote?
Yes.
Thank you.
With that, the motion passes 6-0. We are now ready for staff's presentation in case S12812.
Thank you, Mr. Chair. So this is a request to subdivide 2 lots into 2 lots with vacation of the 50-foot patent roadway reserve along the south and west property boundaries of BOM Lot 46 and along the north property boundary of BOM Lot 52, dedicated by Book 214, page 356. So this request is being made to allow for the unused road reservation land to be vacated and then allow the property owners to use the land. The proposed lots meet the minimum size and width required by the R6 zoning district, and as stated, the petitioners requested vacation of that 50-foot roadway reserve. So originally, this is another one that we went for quite a while, worked with the surveyor. The original owner, I believe it was Schaefer, they came in, wanted to vacate their section of the, as other owners in the area had, of the 50-foot reserve. And planning staff recommended, hey, maybe grab your neighbor and vacate this whole thing, because we would like to see just all of it vacated, and that would kind of clean things up a little bit. So they met with their neighbor and they submitted this application, and we're here to support that. So with the vacation request, we find condition 1 has been met. The patent roadway reserve is part of 2 original patents, with the other half of the reserve being vacated in previous platting actions. So the properties adjoin Jupiter Drive and Carlson Road respectively. Those are local roads. With this plat, they're going to dedicate 50 feet of right-of-way for Jupiter Drive and 30 feet of right-of-way for Carlson Road, which meets all the necessary right-of-way widths. And the reserve is surplus to the current and future needs of the public because 20 feet for Carlson Road. So staff finds condition 2 has been met. The section pertaining to the plat right-of-way is not listed on the classification listings in the official streets and highways plan. Jupiter Drive and Carlson Road, their future needs for right-of-way are met. 3 and 4, it's not laying on the half-mile or quarter-mile grid. Condition 5, the remaining property will be served by existing and dedicated right-of-way. It will not deny access to any property with this vacation. Everybody will have access. Condition 6 has been met. The roadway reserve to be vacated is a remnant from the original patent. There is no realignment of roadway proposed, and the vacation will not impact existing traffic circulation. Generally, reviewing agencies had either no comment or objection to the vacation request. Therefore, staff believes that that 50-foot patent roadway reserve is in excess of municipal need and recommends approval of the vacation subject to conditions A and B found on the staff packet. I believe that the vacation exhibit in 11, on page 11, is probably the best description there, where it kind of shades things. It was good that they were able to get their neighbor and come in and vacate this, and then they can use the vacated right-of-way for maybe a garage or an addition or part of their driveway. Thank you. I'm happy to answer any questions.
Thank you for that presentation. Mr. Cross has a question for you.
I have more of a general question, which is it not within your authority whenever you have an easement or something that's beyond use that you could just give a public notice that it's your intention to remove it? And if nobody complains, just remove it? I mean, seems like for something that you all agree should go away, making the petitioner spend a ridiculous amount of money to resolve an issue and jump through all these hoops could just simply be done with a staff that we have on hand who's already aware of it and could do it. Thank you.
Oh, yeah, through the chair, Mr. Cross. Yes, there is some abbreviated plat stuff that we can do for some utility easements and things like that. But when it comes time to vacating right-of-way reserve, a municipal right-of-way, we do have to go through here. Plus, they're doing a plat tonight as well. So they're going to actually, once that's vacated, their property lines are going to, they're kind of increasing their property. So there'll be a regular subdivision plat associated with this as well.
Thank you for that question, Mr. Cross. Any other questions of staff? Seeing none, we are ready for the petitioner's presentation.
Good evening. Through the chair, members of the board, my name is Tony Hoffman. I'm working with the Boutte Company. And tonight on this case, I'm representing the owners of these two BLM lots on Jupiter and Carlson. I think staff has done a very good job of representing what we're doing. We did try to get the owner of lot 45A, which is north on the other side of the vacated right-of-way on our new Jupiter lot 2, because they had already vacated part of the 50-foot right-of-way in 99. However, why they didn't vacate the rest of the 30 feet at the time, the city may not have thought it was in excess, but this BLM reserve right-of-way or reservation that runs east and west through here, it doesn't show up on any maps. It really doesn't even have a name in the municipal mapper. So it's clearly in excess, but the owner of lot 45A didn't want any part of it. So that's why we have these two odd lots that are perpendicular, whatever, adjacent to each other. The owner of lot 51A in that 93 plat, he went through this process already. But he had already gone through this step. So we did want to include that guy to the north lot 45A in this, but he didn't want any part of it. So on Carlson, we're leaving the 30-foot strip because that is shown on some of the plans as a dedicated right-of-way. So we're just reducing it to the municipal right-of-way requirement of 30 feet. We're taking 20 feet of that, 50, and then it'll revert to the acreage for our new lot 1, as well as that 50 foot on the south side. On our new lot 2, that 50-foot easement will go away and it will revert to the acreage of our new Jupiter lot 2. So that kind of explains what we're doing. This one isn't nearly as convoluted as others you've seen tonight. It is a pretty straightforward vacation, but these BLM patent easements you see everywhere. And a lot of them are in areas that they need to go away. So this is an excellent example of that. And this whole area has been doing that over the years. If you look on different plats up and down between Carlson and Jupiter, it's a recurrent theme. Other than that, I really don't have a lot to say about this. It's a pretty straightforward plat. It's a reversion to acreage of some of these unneeded right-of-ways. So I'll reserve the rest of my time.
Thank you. You have 7 minutes and 23 seconds for rebuttal.
Thank you.
Are there any questions of the petitioner? Mr. Jones.
Thank you. And looking at the plat here on 11, properties to the, I guess, north and south or left and right, depending on how you're looking at it here, to the on the Carlson Road side, I'm seeing that those adjacent properties look to have 50 feet or so right away, and then you're giving 30 feet on that, and that's just based on the requirements of what's for Carlson versus maybe what was, I guess, assumed maybe?
Well, so on the other side of Carlson, up and down, they haven't done any of these. They still have a full 50-foot right-of-way from center line. So we're still retaining 30 foot on our side because that's the minimum municipal standard for a road. But those other ones on the other side, they haven't done any of these vacations, and people don't start doing these until they either start building into those section line easements or BLM patent easements, and it doesn't look like a full road. It doesn't look like there should be anything there, and it's not a real big road. Let's put it that way. It's a very rural paved road down there, and it's not in real good condition, but nonetheless, That's why you see, there's still, right across from our new Lot 2, there's still going to be an 80-foot right-of-way there. So those people could always come in here and objection to them vacating 20 feet of it. But, you know, right now it's shown as 50-foot right-of-way on their side of the center line, so there's still plenty of right-of-way going up and down Carlson. I hope that answered your question.
Yes, thank you for clarifying.
Sorry.
Any other questions of the petitioner? Seeing none, we are now going to open this up for public testimony. Is there anyone wishing to testify? Seeing none. Yep, seeing none. You're on to rebuttal. You have 7 minutes and 23 seconds.
I think we've said everything we need to say tonight. Thank you very much for your time.
Thank you. Do you have any final questions? Seeing none, we're now going to close the public hearing. Do we have a motion on the vacation? Moved by Mr. Merca, seconded by Mr. Jones. Mr. Merca, would you like to state your motion?
I move in case S12812 to approve the vacation of the 50-foot patent roadway reserve along the south and west property boundaries of the BLM Lot 46 and along the north property boundary of the BLM Lot 52 dedicated by Book 214, page 356, subject to the conditions shown on page 6 of the staff report.
Thank you, Mr. Merca. Would you like to speak to your motion?
This time I will, yes. Again, a very straightforward case, and thankfully we saved it for last, but I see no reason not to support this motion. Staff has outlined perfectly all of the considerations have been met, and I intend to support the motion.
Thank you, Mr. Merca. Mr. Jones, would you like to speak to your second?
Yes, thank you. I would agree with Mr. Merker's assessment on this. I think staff did a good job of summarizing what we need, and the petitioner's representative gave a good job of overview this. I think this is good. These BLM, easements that are there, clean these up where possible. I think this allows for more development of the lot, garage, ADUs, whatever the folks there might deem they want to build. So overall, I think it's good, and I will support this motion. Thank you.
Thank you, Mr. Jones. Is there anyone else that'd like to add findings?
Yes, through the chair. Just want to mirror the comments from the other members. Definitely support this motion, support the findings of the planning department. Again, it is really nice to see neighbors working together. You don't see that very often. It's nice that we see it twice in a row. No reviewing agencies objected to this road reserve vacation. The road reserve vacations will not impact future connectivity with existing subdivision. They're also in excess and unneeded. AMC 2103-230A, the information provided in the department's recommendation holds merit. There were no public comments. The community council didn't comment, so everybody seems to be okay with this.
Thank you, Ms. Butler. Anyone else wishing to add findings? Seeing none, let's call the vote.
Ms. Butler, how do you vote?
Yes.
Thank you.
With that, the motion passes 6-0. Do we have a motion on the approval of the plat? Moved by Mr. Merca, second by Mr. Jones. Mr. Merca, would you like to state your motion?
I move in case S12812 to approve the plat for 24 months, subject to conditions shown on page 6 and 7 of the staff report.
Thank you, Mr. Merca. Would you like to speak to your motion?
No other findings.
Thank you. Mr. Jones, would you like to speak to your second?
No additional findings from me as well. Thank you.
Thank you, Mr. Jones. Any additional findings? Seeing none, let's call the vote.
Ms. Butler, how do you vote?
Yes.
Thank you.